Good evening, everyone. This is Erin Burho, and this is my presentation on filial responsibility, taking care of mom and dad. Can you imagine one day finding out that you owed $100,000 in medical expenses that weren't even yours? It's possible, and it happened in 2012 to John Pitas, a man from Pennsylvania who found himself drowning in his mother's overdue medical bills. Healthcare and Retirement Corporation of America successfully used Pennsylvania's filial laws to reach John Pitas' assets to compensate the cost of his mother's nursing home expenses. John Pitas' mother had suffered injury in an automobile accident and spent some time rehabilitating in a nursing home. After her recovery, she moved to her home country of Greece, but left behind $93,000 in unpaid nursing home bills. The nursing home obviously wanted to be paid, so it sued Mr. Pitas for the entirety of the debt. Apparently, Mr. Pitas and his mother had applied for Medicaid, but her qualifications were not yet decided at the time the nursing home incurred the expenses. Ultimately, what the court decided was that the nursing home did not need to consider other sources of income, including Mrs. Pitas' husband and two other adult children, nor was the nursing home obligated to wait until a Medicaid decision was reached on the mother's pending Medicaid claim. Therefore, Mr. Pitas was stuck footing the entirety of the bill for his mother's rehabilitation. This case is just one of many examples when an unsuspecting medical bill from a parent may become the responsibility of a child. Now, you might be wondering, what exactly is filial responsibility? Essentially, filial responsibility is a set of laws that about 30 states impose upon adult children to support their impoverished parents. In some cases, the duty might extend to other relatives like aunts and uncles, but most states only apply this when they are already assigned the legal health care proxy. The federal government has neither instituted nor enforced filial laws and has left each state to enforce these laws by specific government health care programs or by private entities. Filial responsibility laws are typically invoked by civil enforcement, but can accompany criminal penalties if issues of neglect or elder abuse are present. There is a common misconception that it is a parent must be elderly to require a child to take on filial responsibilities, but it could be triggered by a number of circumstances, including mental illnesses, chronic illnesses, terminal illnesses, and this is highly dependent on the wording of each state's statutes. As I'll discuss in a minute, they are very state dependent. But all do tend to incorporate an element of indigency, and that a child will be responsible for a parent when the parent has no financial default for their own care and maintenance. Filial responsibility actually originated in Eastern societies and Confucianism and centers around the age-old concept of filial piety. Filial piety refers to this idea that it is a child's greatest privilege and responsibility to be good to one's parents so as to bring honor to the family name in the community. Not only was filial piety service, respect, and obedience, but it also meant making sure parents were comfortable in every single way, including with food, accommodations, clothing, and hygiene. Most modern Western filial support laws are an outgrowth of the Judeo-Christian theology and a duty to honor one's parents unconditionally. It first became written law during the Elizabethan era of the 1600s England and has since been reflected in American common law. At one point, all 50 states had statutes obligating an adult child to care for his or her parents, but over time, about 20 states have repealed their filial support laws. This is primarily because Medicaid took a greater role in providing relief to elderly patients, taking the physical and financial burdens off of children. However, most states still have an archaic remnant of these laws on the books. Filial responsibilities typically obligate adult children to pay for their indigent parents' food, clothing, shelters, medical needs. Should children fail to provide adequately, the law allows nursing homes and government agencies to bring legal actions to recover the costs of care. Generally speaking, the obligation to pay for a parent's medical care will more than likely apply if one or both parents have nursing home bills they can't pay, or one or both parents qualify for indigent status, which means their Social Security benefits don't cover their expenses, or one or both parents are ineligible for Medicaid to help pay for long-term care. I live in Connecticut, and Connecticut happens to be one of those 30 states that have filial responsibility statutes. But what is unique to us is that it only applies to parents under the age of 65. So basically, it becomes a non-issue in most long-term care situations, but would be most prevalent if a parent was faced with a terminal illness and did not reserve enough personal resources to provide for long-term or end-of-life care. On this slide, you'll see a list of all the states that have filial responsibility laws. I wanted to share a few state examples with you so when you do your research on your own state, you can kind of have an idea of what to expect and look for. Arkansas, for example, has filial responsibility laws, but can only require payment for adult mental care. So care for a parent with early onset Alzheimer's might trigger these responsibilities, while Parkinson's disease may not. California, on the other hand, requires an adult child, to the extent they are able, to support a parent who is unable to support themselves. A parent or the county on behalf of the parent may even bring an action against an adult child to enforce this responsibility. California considers factors in determining the amount of support a child might be obligated to pay. These factors include both the adult and the child's earning capacity, other financial obligations and assets, age and health complications, pre-existing standards of living, and whatever else the court might find equitable to consider. Massachusetts law is also unique in that it requires any adult child who has sufficient means to provide support and maintenance for a parent, if the parent, through misfortune and without fault of his or her own, is destitute and is unable to support and maintain his or herself, and both parties are living in the state of Massachusetts. That's a direct quote from the statute. The law therefore seems less concerned about the kind of care is actually required and considers more what is the most equitable for both of the parties. Tennessee, on the other hand, has a very broad definition of who a nursing home and a long-term care facility can actually go after for reimbursement. These care facilities can go after any responsible party, which may include parents, spouses, children, guardians, conservators, and in some circumstances, healthcare proxies. But basically anyone who had the primary responsibility for that person's care and well-being to begin with. Virginia law has a caveat that requires all adult children share equitably in the discharge of the duty to support their parents, which means filial responsibility would never fall to one child, and it's a joint requirement. It is still based on an equitable standard, and no person would owe more than they could take on, but if the court determined that an adult child has failed to render his or her proper share of the support and maintenance, then the court may compel back pay or reimbursement by the adult child to their siblings or to the facility itself. Nevada law is interesting because it follows basic contracts principles. So the traditional notion of having certain responsibilities to a parent for their health and well-being has been pretty much eliminated by requiring a written agreement to pay for care. This could come from an initial agreement with a healthcare facility or a written agreement between the parent and their adult child themselves. But ultimately, equitable means or health issues are not the deciding factor in Nevada. For a vast majority of people, the growth of state-administered Medicaid programs to pay for nursing home costs made filial support laws obsolete. But with skyrocketing healthcare costs and the aging baby boomer generation, providers are more than likely going to seek reimbursement for extensive adult care that goes unpaid. So the filial laws could sneak up on someone whose parents' financial status prevented them from using Medicaid, even if the child is not ideally suited to take on full-time care or the financial burden of caring for their parents. Under federal law, a state cannot pursue family members for reimbursement of the costs of care if a parent is eligible for Medicaid coverage. However, the child may still end up effectively paying at least a portion of the cost of a parent's care from an inheritance through Medicaid's estates recovery programs. States can recover the amount Medicaid spent on an individual's behalf from his or her own estate after death. So assets included in Medicaid recovery, such as real property, a house, or other personal property, might be vulnerable. For those of us in Connecticut, there is a statutory mechanism that could be used against the families of Medicaid applicants. Section 17B-261 gives nursing homes the ability to sue when a penalty period is applied due to a transfer occurring within 2 years of filing for benefits. What is particularly unnerving about that law is that nursing homes are not limited to pursuing a claim against the person who made a gift, but they can also seek a recovery of the debt against those who received such gifts. So the traditional means of transferring assets around to be eligible for certain Medicaid programs may not completely shelter an adult child from filial responsibilities. In general, the trend seems to be shifting to make it harder for nursing home residents to qualify for Medicaid benefits and to avoid penalties being assessed on their eligibility. So, with that, long term care facilities may start more aggressively suing residents and their family members for overdue payments. In particular, I read an article while searching this topic that I felt was important regarding the COVID-19 pandemic. The pandemic has brought this otherwise archaic concept to the forefront of the medical community's attention. After all, the disease disproportionately affects the elderly, and people between the ages of 65 and 74 are 5 times more likely to be hospitalized from COVID than those between 18 and 30, according to the CDC. So, where a simple doctor's visit or a missed copay on medication is not likely to call filial responsibilities into play, long term care during the pandemic might. The combination of the patient being isolated, the family not having access to information that would allow them to sign their parents up for proper Medicaid, and the length of recovery times from the virus makes the circumstances ripe for growing debt that the patients and their families likely can't afford. It is important to ask ourselves, when would I be obligated under a filial responsibility law? What can I look for to help determine if my client might be under a filial responsibility? Obviously, the first thing to know is, does my state even have filial responsibility laws? If that's not in your state, then this whole conversation is a non-issue, and you are lucky. But just remember that more than 30 states in the United States still have a remnant of these laws in the books. Second, you would want to know if your parents or your client's parents qualify for Medicaid. For other tax purposes, this is obviously good to know as well, but in many states, it's going to alleviate the filial responsibility altogether. If your parents can legitimately qualify for Medicaid, that dramatically lowers your risk of absorbing their medical debts. There are also legal Medicaid spend down options to lower your parents' income and assets enough for them to be eligible. Third, ask, do your parents or your client's parents have the funds available to pay for their bills? Almost unanimously across the board, a requirement for filial responsibilities of a child is indigency for the parents. That makes sense, right? Because if there are assets and finances in the parent's estate, they should have the burden of paying for their own healthcare costs and maintenance, not the child. Fourth, are there retirement or Social Security benefits that can cover these expenses? Again, it is a state-specific concept, but in some places it's not impossible for these assets to be reached when they are outstanding medical costs. Fifth, is there another long-term care insurance in play? Perhaps the best way to ensure that a parent isn't paying out of pocket for health care by default is knowing what insurance programs they are under and the coverage that they are receiving. This is an especially important conversation to have with clients when they want to set up medical directives or end-of-life care. And although there are not many options, there are ways to avoid filial responsibilities. Many states provide exceptions to a child's filial responsibility if there is evidence in the past that the parent was abusive, neglected the child, deserted the child, or failed to support the child when he or she was a minor, which would then absolve the child of paying for the liabilities of the parents as an adult. Probably the best way to just avoid filial responsibility is to speak with the parents or your client's parents concerning their estate planning and their long-term care needs. It may be an awkward conversation, but it is a necessary one, of course. If you think it is unlikely that a parent will be unable to provide for their own care in the long-term foreseeable future, and that they wouldn't receive Medicaid, then it may be worth considering purchasing long-term care insurance on the parent's behalf. If you live in a state with filial responsibility laws, these laws should be considered in all major financial decisions and long-term healthcare planning. Ignoring these laws is what's going to get people into sticky situations. So things to keep in mind. 1, you definitely can be sued for your parents' long-term care bills. The last thing you want to do is be like Mr. Pitas, who one day is waiting for his mother to recover in a nice temporary healthcare facility, and the next thing he knows, he's facing a mountain of her debts. 2, Be mindful that you could face civil or criminal penalties by failing to fulfill your filial responsibilities. If a court finds you responsible for a parent's medical bills, you will be subject to the usual debt remedies, like bank account seizures, liens, and really whatever they can do to get the repayment. You could face jail time, although that's unlikely. But if it was extensive enough debt or it was deliberately avoided, it's not out of the realm of possibility. 3. Remember, financial transactions between parents and children are not always exempt from filial laws. The law could view those transactions as fraudulent conveyances that were intended to defraud creditors or just a costly error in judgment. Either way, be careful to avoid violating Medicaid asset transfer rules and just expect that these transfers will be scrutinized. Finally, and here's some good news. Siblings or your parent's spouse will not be exempt from paying their fair share of the filial responsibilities. Again, you'll have to look at your statute to see what it says, but siblings are required in most cases to share filial responsibilities. And even if a healthcare provider came after you specifically, you could still seek compensation from your siblings. Here are some additional resources for your consideration, but I believe this concludes my presentation on filial responsibilities. Thanks for listening.